I'm Rielle Morgowitz. I'm one of the attorneys at the New York State Department of State. The Department of State offers technical assistance and training to local governments and community organizations throughout the state. Recently, state statutes were amended to require that all members of municipal planning boards and CBAs be required to complete 4 hours of training annually. As part of that, the Department of State is trying to provide a number of new alternatives for you to receive this training. What you're watching now is just one of these new avenues to receive training. The Department of State will also be presenting materials via online training and, of course, our in-person training classes that are offered throughout the state. In just a moment, the presentation will move over to the slideshow. What will be accompanying the slideshow is my voice going through, giving you more information about everything that's going to be contained in a particular slide. If you wish, you may download a copy of that slideshow presentation and make notes on it as we go along. This presentation will also be available on CD to be watched at your convenience. This presentation today is called Locally Unwanted Land Uses, or LULUS as they are sometimes called. These are land uses that the Department of State has identified as ones that are often causing some dissension in municipalities when an applicant comes before a board looking for approval. This is going to be a broad overview of the LULUs. Given the fact that these are all very in-depth topics, you may wish to look into them separately. I am going to provide you, as we go along, other alternatives for getting more information about a particular LULU. In many cases, the Department of State has on its website a publication on the particular issue, and I will make sure to draw your attention to that fact. I hope you enjoy the presentation, and if you have any questions, please feel free to contact me in the counsel's office or any member of the land use training staff as part of the Division of Local Government. The phone numbers for both of those offices will be included as part of the PowerPoint, and they are also available on the Department of State's website. Thank you. So, as I said, make sure to make note of your questions as we go along. Again, this is going to be a broad overview of a few LULU topics, and as part of that, we're going to jump right in. So let's talk about some of the terms that we often hear with regard to these locally unwanted land uses. Obviously, the first one is the LULUs that I've already mentioned. This is locally unwanted land uses. The next one that you'll often see I think in newspapers and other write-ups, law review articles, all sorts of things, is NIMBY, not in my backyard. The third one we have is NIMI, which is very similar, and that's not in my election year, where you have an elected official who doesn't want something contentious to occur when they're running for office. Next one is NIM2, not in my term of office, so meaning not while I'm actually presiding over something or might have some input on it. It's not what somebody wants to maybe be remembered for. Nope, not on the planet Earth. And as you can see with these next couple, we're having a little bit of fun with them. The next one is banana, build absolutely nothing anywhere near anything. And I think that that's a very creative one personally. And then finally, we have caves, citizens against virtually anything. And again, we've taken something and we've kind of stretched it out to the extreme to bring a little bit of humor to this particular presentation. So, now that we know some of the terms that come up, let's talk about things that we can do. And the bottom line is it always is going to start with good planning. Whenever we're talking about land use issues, the bottom line is planning is imperative. And I often like to think of the Boy Scouts in this regard. Their motto is to be prepared. And any part of good planning and zoning is to do the same thing. It's to be prepared. It's to be prepared for those things that, oh, that'll never happen in our particular town or village. It very well could. And if you're prepared ahead of time, you won't be caught short when one of these locally unwanted land uses comes before you with an application. And there's really not much you can do. So what do you do in terms of good planning? Provide legal support for your regulatory changes. So what does this mean? Legal support is many different things. It's you're trying to make sure that whenever you adopt and amend your zoning, that it conforms with your comprehensive plan and any other policies that have been adopted in the municipality with regard to land use. It's showing your work. It's providing backup information. It's making sure that everything is cohesive and meshes with your comprehensive plan for the municipality. So what else do we want to do as part of that? An important thing is to prioritize your your municipal infrastructure investments. Now, what do we mean by that? It's not just the simple things like your roads, your sidewalks. It's other things. It's stormwater, it's water, it's sewer. All of these are aspects of infrastructure that are absolutely imperative to make sure that your municipality continues to grow in a way that is going to keep everyone there happy and healthy. Now, as part of your planning process, you may also want to identify areas for potential private investment in infrastructure, especially maybe in industrial areas or commercial areas where you're going to have larger uses and they're going to put more burden on your infrastructure. In that instance, you're especially going to see things when you're dealing with traffic, water, sewer, and wastewater. Involve your public in the process of and how do you do that? You seek out public opinion on controversial issues. You make sure that everything is as open as it possibly could be. You invite the public to come whenever there's going to be a public meeting, a public hearing. You make sure it's well publicized. Another good thing to do is to have informational sessions that the public can attend, and we'll talk a little bit more about that as we move along. Now, here's the thing that you need to remember, and what is really the backside of not having good planning, is that when there's no planning or zoning, locally unwanted land uses, like we're going to discuss throughout this presentation, are only going to be governed by private deed restrictions and common law nuisance, which is basically going to leave the municipality without much ability to address the potential side effects or address the issue at all. Now, this slide is interesting because I think you hear this a lot from your citizenry. It's, we know we don't want it. So what exactly was that mean? What does that mean? If you don't want a particular use in your municipality, you really need to make sure that you address it in all ways possible. Because sometimes just because you don't want a particular land use in your municipality, it does not mean that you're going to be able to keep it out entirely. So look at a lot of different things. Consider your code as it stands, and do you already even allowable use? Sometimes we've run into cases where a municipality actually does allow the use and they just didn't even realize it. So it's important to look at your zoning code going in and making sure that there's a number of things in it and that it's very clear. The first thing, as you can see, is your zoning clear? How can you tell if your zoning is clear? Do you have vague definitions? Is your code enforcement officer constantly being questioned as to whether or not something meets a definition? Are people appealing to the Zoning Board of Appeals for interpretations of your code enforcement officer's decisions? If you see this happening on a regular basis, I would feel safe to say that you may want to go back and look at your definitions and to see what's vague about them and see if they can be tightened up and address those issues that people are asking questions about. It's important to remember, too, that a lot of times when you're dealing with locally unwanted land uses, you have groups that can be very creative in trying to use your zoning in a way that benefits them and perhaps is not what you really had in mind for your community. So what's next? Does your zoning match up with your comprehensive plan? It's imperative that your zoning be done in accordance with your comprehensive plan and any other land use policies that have been enacted by your municipality. Make sure they match up. If you have a comprehensive plan that says you want an entirely residential area with very little commercial use, but your zoning basically says that the entire community is zoned commercial and industrial, obviously those two things would not work out and they don't mesh together. You want to make sure that one is a reflection of the other. Now, generally, a lot of municipalities will, when they are putting in their definitions and their different sections that set up zones, will have a, I'll cut that and go back. Generally, zoning laws will contain a provision which states that the uses not listed as allowed are then prohibited. This is a very safe and easy insertion to put into your zoning code because it will help you in terms of someone saying, well, it's not listed, so what does that mean? Is it prohibited? Is it not prohibited? If it says, if it's not listed, it is prohibited. That will help you in terms of dealing with maybe some of those things that you haven't actually thought of as something that could happen down the road. You have to remember, as I said at the beginning of the slide, though, that there are certain uses that have some protection, and you're not going to be entirely able to zone them out of your municipality. A couple of them that are protected either by state or federal law are things such as affordable or low-income housing. You cannot have a complete ban on adult uses. And The Religious Land Use and Institutionalized Persons Act is a federal law dealing with religious property that may also come into play in your municipality. Again, these are things to be considered when you are adopting your zoning and also as you are applying your zoning. We prohibit it. This also becomes the big question after we know we don't want it. Exclusionary zoning is one of the things that needs to be discussed when you're talking about locally unwanted land uses, or LULUS. Exclusionary zoning has been defined as land use control regulations which singly or in concert tend to exclude persons of low or moderate income from the zoning of the municipality. So what exactly does that mean? That means not so much that you're trying to say we don't want low or moderate income families in your municipality, but you're trying to actually accomplish that for your zoning. A lot of ways that municipalities, I should say, do that are through things like large lot zoning. Large lot zoning would require that for any residential home, you have lots in excess of perhaps 2 or 3 acres, which is in most cases much more land than you could possibly need for a home. But it also increases property values and increases the cost of home ownership, thereby excluding a lot of lower and moderate income families. Another method of doing this would be high minimum square footage requirements. Again, this tends to increase the cost of houses, and it can also be used in some cases to try and prohibit the installation of mobile homes in a community. You can try and exclude multiple dwellings. There's also the attempt to exclude mobile homes, which is something that's very problematic and that you cannot completely ban. And we are going to discuss in further detail in one of the future slides. You could have non-residential uses excluded if the action is supported by the comprehensive plan. Now, that's a little bit different again from our residential uses. Non-residential uses would be along the lines of the commercial uses. So you can exclude many of those completely, but you have to remember, as I mentioned in the previous slide, that many of these have constitutional protections that need to be followed in terms of trying to zone these issues out. So again, a municipality can exclude almost all commercial uses, but you have to remember that there are a few that there are problems with, especially along the lines of adult businesses and religious uses. Can we rezone to help out one applicant? The answer to that question is no, not if it's inconsistent with your comprehensive plan. You can rezone to accommodate an applicant seeking a zoning amendment to allow a use that the comprehensive plan supports. So let me give you a very basic example of that. A person comes to you and they want to build a residential home. They are located in a commercial district, but it abuts right up next to a residential district. An alteration of the line would be very small and would fit in with the character of the surrounding homes. Looking at the comprehensive plan, it falls into place, and a zoning amendment along those lines would be considered fine because it melds with the comprehensive plan and it is not just trying to create a special circumstance for one person. Now, let's use another really far-flung example and say that we have a residential district and a big box retailer comes along and says, we want to build our big box store in the middle of this residential district. Now, the only way we're going to be able to accomplish that is if you rezone the entire section where we are going to place this. Now, if you were to rezone that section, I would say that's probably going to fall along the lines of spot zoning. I seriously doubt your comprehensive plan actually envisions building a big box retail store in the midst of a residential district. But again, the examples I'm using are pretty far flung. So think about it this way. Zoning changes must be reasonably related to a legitimate public purpose, and by that we usually mean things like providing for orderly growth and the development of the community. And if not, you're going to start running into a phrase that's out there quite a bit, and it's called spot zoning. Spot zoning is illegal as all zoning must be done in accordance with a comprehensive plan, and spot zoning is not. Now, as you'll see in the slide, and this is a quote from the Rogers versus Tarrytown decision, the process of singling out a small parcel of land for a use classification totally different from that of the surrounding area for the benefit of the owner of such property and to the detriment of others is considered spot zoning. So again, look at it in its overall picture, look at it in terms of the request for a zone change as to whether or not it fits with the zoning and with your comprehensive plan overall. If it does not, you may be in danger of creating spot zoning. Can we deny an applicant based on community opposition? This is something that comes up time and time again, because usually when you're dealing with a LULU, there's a lot of people in the community who are very, very interested in the topic and want to do everything they possibly can to prevent a particular LULU perhaps from coming into the community. So a lot of times where you've had, maybe months or years of not many people attending a ZBA or a planning board meeting, all of a sudden you have tons of people in the audience, and they're all wanting your attention, and they all want to put in their opinion. That is fine. The problem becomes when you make decisions based solely on opposition from the community. And let me say, first of all, here that I do understand that there is a lot of pressure from the community. These are the people that you have to see in the grocery store and at the post office and at the Little League games and things like that. So I understand how difficult this position can be in, especially when the community is adamantly opposed to the particular LULU. But it's important to remember that as members of planning boards and zoning boards, you have to follow the law. So basically, if the use is allowed by the zoning and the requirements are met by an applicant, general community opposition is not going to be a valid basis for the denial of a land use application. Any decision that's based solely on community opposition or seemingly only based on community opposition is going to be subject to invalidation by the courts. Boards making decisions must follow the law. For example, if it's something that's subject to a use variance, the ZBA has to follow all 4 prongs of the use variance test. And if an applicant meets those 4 prongs, then the use variance should be granted. However, I would like to throw out there that just because a community is opposed to something doesn't mean that you can't decide the way that they are thinking. If community opposition can be tied to actual problems or issues with the applicant, then that can be part of your decision. It cannot be the sole reason. So let's say someone in the community comes forward and says, listen, I believe that this area is a wetland area, and there's going to be wastewater issues and stormwater issues, and there's not adequate sewer to support something like this. Now, if the ZBA or planning board were to go on and investigate those claims and find, yes, that person actually was correct, there's all sorts of environmental impacts that need to be dealt with here, that would mean that they were still finding a valid basis for their decision. It would mean they had supporting evidence just beyond someone saying, oh, I think there's a problem with this, that, or the other, or the classic, I just don't want it here. So again, make sure that your decisions are supported, and we're going to talk about that a little bit more as we go through the entire presentation. Again, so public comment can be substantive, and it can also provide necessary information that perhaps the board was not privy to for one reason or another. But weigh that against actually making sure that there's backup for that public comment. Now, we're going to catch our breath, meaning that this is a situation where a LULU has perhaps been rumored to be coming to town, something along those lines. So what are one of the things that you can do? One of the things that many municipalities choose to do is to adopt a moratorium. At this point, I'd like to point out to you that there's a publication called Land Use Moratorium that's available for download for free on the Department of State's website under the local government section. This is an extremely helpful publication and has a step-by-step guide that explains how to properly adopt a land use moratorium. It also provides a little bit more information about the legal background in adopting a moratorium. So, how do we do this? What's the first step? The first step is to remember that a moratorium is actually a legislative act. That means it needs to be adopted by the governing body of your municipality. That would be the town board, the city council, or the village board of trustees. So, this needs to be done by a legislative body, and it needs to be a legislative act. It's going to be a local law because you're going to be amending your zoning. So let's talk about a couple frequently asked questions or issues that have to do with land use moratoria. The first one that usually comes up is land use moratoria subject to seeker. It is a type 2 action under seeker, so the seeker review is going to stop right there. Now, what's next? How long can a moratorium be? A moratorium must be for a certain short duration and no longer than necessary to effect a permanent solution. The time period of the moratorium needs to be specified in the adopted legislation. By that I mean you have to say this legislation is going to be in effect for 6 months from the date of the adoption or 3 months from the date of adoption. And again, the time period needs to be reasonable to effectuate the goal that you're looking for. So let's say that your goal is to review your subdivision regulations and zoning. So how long is that going to take? Perhaps 3 or 6 months. If you feel that 6 months is reasonable, make sure that there is actually a basis for that decision, and then put in place that it will be for 6 months. Now let's say at the end of 6 months, you haven't actually gotten all the work done, but you've been moving along nicely, you've been getting lots of new information, and what do you do then? The moratorium's running up, your time is short. Do you try and throw something together and get it out there? No. You can amend the moratorium to enact it for extensions, usually 3 months, sometimes a month. Again, it should be reasonable, and it should be reasonably related to the time you actually need. So let's say you're running up at your 6-month time period, but you need another month to complete. You would adopt another moratorium to extend for a 1-month period after that. And again, extensions can be adopted as time goes by. But the important thing to remember in terms of extensions is you need to actually show that you're doing work. So you can't come to the end of the 6 months, have accomplished absolutely nothing and not even opened the book on subdivision regulations, and then expect to be entitled to an extension by the courts. So what else do we need to do? Because this is a legislative act, you need to go through all the proper procedures, meaning it has to be properly noticed, it has to have a public hearing, things along those lines. And if you have questions about the adoption of a local law, there again is a publication on the Department of State's website that talks about the adoption of the local law and the process involved. The final thing you really want to remember is that moratorium need to be enacted for a specific purpose. A specific purpose should not be, we want to keep big box retail out of the municipality. A proper purpose would be, we need to review our site plan or subdivision regulations to make sure that they are applying properly and that we are able to continue developing the community in a way that forwards our comprehensive plan. That would be more appropriate. Now, let's talk about some acceptable reasons other than the one I just gave you. A very popular one is to update your comprehensive plan. Perhaps it hasn't been done in 10 years and there's a lot of changes going on in your municipality. Or you realize that there's new uses that may be coming your way that you want to address. You could also do it to prevent inefficient or ill-conceived growth. This is always going to be a problem. You don't want your community kind of spiraling off because things haven't been revisited in a timely manner. To prevent hasty decisions is another good reason. To update regulations, like your subdivision regulations. And then to prevent immediate construction, which might be inconsistent with a future plan. Now, what are the wrong reasons? I gave you an example already, but as you can see, there's a couple more here. To slow down development in hopes that a developer will go away. This is not an appropriate reason to adopt a moratorium. And then also to halt development while the community tries to consider buying the land or try and find some other buyer for land. Again, that has been considered inappropriate reasons to adopt a moratorium. Okay, so we're moving right along and we're still dealing with our LULUs in our community. What's another good way to approach this? Inform and involve the public. Now, this is very important because the public can be your best friend or your worst enemy in terms of issues like this. So the more quickly you involve them and the more information you give them, the less problematic it will be as you move along. Also, it's important to inform yourselves. Review boards should unearth controversy as early as possible when applicants are more receptive to change and before the public actually feels steamrolled. People are most often upset when they feel that things were kind of snuck in at the 11th hour. So again, if you think an issue is coming to town, maybe you want to start holding public information sessions on it. You want to try meeting with the applicant as early as possible and say, this is the kind of community we are developing. Keep that in mind. You may want to keep that in mind as you move forward with your application. We have certain design standards. We have architectural review. We have all sorts of different things, and we would like to work with you, but we would also like you to work with us. So, as I said, keep working with the public. Is a public hearing required as part of the application? More than likely. If so, make sure that it is well publicized. Now, that goes beyond just the legal notice in the paper and the open meetings law requirements. This could also be posting it on your website if you have one, or in a municipal newsletter if you have one. There's a lot of different opportunities out there if you look around a little, and a lot of communities have been extremely active in terms of getting the word out as much as possible. Now, remember again, you can hold informational settings with the residents of the community, with leaders, with activists, and anyone who's interested. And I highly recommend it, especially when you're dealing with a Lulu. Getting people involved, addressing their issues, a lot of times will actually cut out a lot of problems. People may come to you and say, oh, I don't want X, Y, or Z for these reasons. And if you can say, well, actually, you know, those reasons we can mitigate one way. Maybe we aren't really a problem that you realized. Maybe it's in a different section of town that you didn't think it was. And a lot of times you can actually answer people's questions up front, and the negativity will actually either decrease or completely go away. So this can be very, very helpful in dealing with these LULUs. If you have any of these meetings, you want to make sure you follow your rules of procedure if you've adopted any. You also want to give people alternative forums for public comment. That could be submitting materials via the email, in writing, any other medium that may be interesting to people. You may be able to get your local cable access to film and broadcast the meetings if they're interested. A lot of people may have worked that out as part of their local franchise agreement, so you may want to look into that. And then again, make information as available as possible. Have copies at other public buildings, maybe at the library, other places that people might frequent. If you have a community center, if you have perhaps a small a museum in your community. These are also good places to have materials available because these are places that the community frequents. And again, I can't stress enough how important it can be to involve the public at an early stage of an application, because oftentimes you can identify and resolve issues and concerns and kind of cut it off at the pass instead of having it be something that lingers throughout an application process and only makes the entire process harder on everyone involved, including the board, the applicant, and the public. LULUs and the media. Now, as someone once told me, the media thrives on controversy. So the more controversial the Lulu is, probably the more interest you're going to have from the media. When you watch the news, how often do you see stories that are going to be about nice, pleasant things and how well everything is going in the village of X or the town of Y? Not very often. You usually hear about the problems that someone is unhappy with the building of a Lulu or something along those lines. So you have to remember that most news people are generalists and they are not experts in the law. Many of them don't understand the mechanisms of local government. They just know what they don't like and what they don't want. So you have to remember that, you know, if you make a reference to a specific section of law, that's not always going to be understood by the media. So keep things as basic as you can. Inform them as much as you can, so provide them with additional information if you think that's going to be helpful. Make sure that plenty of copies of materials are available, and again, this will be helpful with both the media and the public. I think the most important things, though, to remember when you're talking about the media is be careful how you answer things. I think that there are many a public official who made a perfectly wonderful quote to the media, and it got cut up into something that ended up causing more problems because they had that ability to edit down your comment. So perhaps what you want to think about is having one voice for the municipality, meaning all media comments and questions are directed towards, say, the municipal attorney. That way you're going to be answering in one voice, and also you're going to have a lot less of the problem of, well, you know, trustee A said this and trustee B said something different, or council member or town board member. Having one voice can be helpful in limiting the problems that could potentially come up. Now, again, you may want to think about having some press releases. This can be very helpful because you can carefully craft that to make sure it explains all the issues that you want to make sure that the news and the public hear. You want to make sure that when you are talking to a member of the press, that it's fully understood what off the record means. You also want to make sure that you correct any false assumptions. So if you know that there is a widely held false assumption about something, say that a big box retailer is coming to town, you may want to say, no, in fact, we know nothing about that. That would be correcting a false assumption. Be wary of loaded words, meaning words that kind of make it sound you're either being wishy-washy or you're thinking about something else. And again, I realize this probably makes some people uncomfortable in that it's making you be very, very careful when you're speaking to the press. But again, false steps with the press can come back and be very destructive to an application process. It's the same thing with the public. If you give them more correct information in one coherent voice, you can actually prevent problems down the road. Last thing on this slide, as you can see, is not to repeat negative questions. This can be also very helpful because it could again be the section of your tape that's being played back as part of the news or as part of the article that the news media outlet is going to write. Again, this is going to be the second section of our PowerPoint presentation, and this is when we're going to do a quick overview of some of the LULUs that we've identified here at the Department of State. Like I said, this is going to be brief, but it's also going to contain recent information, and it will also give you other options if you wish to look into the issue in more depth. Now, we are going to cover 6 LULUs today, and they are going to include adult uses, and examples of that would include such things as strip clubs, theaters, movie theaters that show adult movies, and also adult bookstores. Another LULU that we're going to be covering today is religious uses, which obviously would cover such things as houses of worship, which include churches, mosques, synagogues, temples, and other buildings. We're also going to cover non-retail uses in retail districts, which is a very important issue for a lot of economic reasons. We're going to cover political signs today, which depending on the time of year can be a very important topic in your municipality. We're going to talk about large-scale retail uses, and that's going to involve places like the big box retailers. Most commonly, we think of Walmart or Costco or Sam's Club or Target, that type of thing. And then finally, we're going to touch upon McMansions, another issue that seems to be burgeoning over the last 60 years. So I hope you enjoy this section, and again, if you have questions, please feel free to contact us via the internet or via the phone numbers that will be provided at the end of the presentation. Dive right into the LULUs that we're going to be going through today. The first one that you'll see in the slideshow is the LULU adult uses. Municipal zoning regulation of adult businesses may be locally popular, but it raises serious constitutional issues when the regulation is directed at free expression protected by the federal and state constitutions. Non-obscene expression, whether it is in the form of a sexually explicit book, magazine, movie, or dancing, has traditionally been found to be entitled to such constitutional protection. When municipal regulations impinge on an adult business's freedom of expression, they lose the presumption of constitutionality that normally applies to zoning regulations, and the burden shifts to local governments to justify the restrictions. Any regulations regarding adult businesses should be carefully drafted and reviewed for legal sufficiency prior to adoption. The goal of these regulations must be to control the secondary effects of the adult businesses. Secondary effects can include urban blight, reduced property values, and decreased retail activity. To date, the United States Supreme Court has not yet held up local legislation that was adopted without regard to the secondary effects as established by a study. Now, what can municipalities do? Municipalities, in drafting their adult use zoning legislation, typically choose between 2 different zoning techniques: either concentrating the adult uses in a single geographic area of the locality, or dispersing the adult uses throughout the community using distance requirements. To give you an example of this, adult businesses can't be located within 100 feet of a church or school. When using this method, be sure to specify where the measurement starts from. For example, is it from the property line or the door of the establishment? This can help also to avoid the skid row effect when adult businesses are dispersed throughout the community. If locational restrictions are enacted, there must also be viable locations suitably zoned for these businesses in the community. In comparison, many believe that the technique of concentrating adult uses in a specific area of the community will affect fewer neighborhoods and can therefore be avoided by those persons who are offended by the adult uses. In the City of Renton versus Playtime Theaters, the United States Supreme Court developed a four-part test to be used when determining when it is permissible to use zoning to single out adult uses without violating the First Amendment of the United States Constitution. In determining the constitutional validity of a zoning regulation, courts must consider 1. The predominant purpose must be to eliminate the secondary effects as opposed to the speech itself. 2. That the zoning furthers a substantial governmental interest. 3. That the zoning is narrowly tailored to affect only those uses that produce unwanted secondary effects. And 4. The zoning leaves open reasonable alternative locations for adult uses. The New York State Court of Appeals developed its own hybrid test using both state and federal constitutional standards in the case of Stringfellows of New York Limited versus the City of New York. The hybrid test is as follows. 1. The zoning regulation must be justified by concerns unrelated to speech, i.e. the secondary effects that are caused by the adult businesses. 2. It must be no broader than necessary to achieve its purposes. And 3, it must provide alternative locations for adult business use. There must be some areas that the adult use is able to locate in. For example, if your zoning creates a situation where adult businesses are not allowed to locate within 500 feet of a church or school, if that creates a situation in your municipality where there is no land that is not within 500 feet of that church or school, this will be problematic under the test. When existing adult businesses are rendered non-conforming by subsequent zoning amendments and directed to terminate operations, the courts must additionally consider whether the amortization provisions allow for reasonable recoupment of the investments in the business. And that would be a potential fourth part to the New York State hybrid test. For more information on adult businesses, please see the Department of State's website for a legal memo entitled Municipal Regulation of Adult Businesses. Our next slide, as you can see, deals with religious uses. Religious uses require special consideration because of their unique standing in our communities. Religious uses are not exempt from zoning laws, but greater flexibility is required when reviewing an application for a religious use, and every effort must be made to accommodate them. It is a difficult argument to make that these religious uses do not comport with zoning, which is purported to protect our health, safety, moral, and welfares, when they often, in fact, represent the morals of the community. This does not mean religious uses are exempt from local zoning laws, but municipalities cannot exclude religious uses from residential zoning districts specifically. As a general rule, don't try and prohibit the use if the impact of the religious use is similar to other uses that are currently allowed in that area. Municipalities can regulate characteristics that can create legitimate concerns for the safety of the community, and some of these include such things as traffic generation, parking, and signage. Municipalities can also require that religious uses receive special use permits or variances to deal with those issues that I just mentioned. Traffic generation can be a special problem as there's often a great deal of traffic going in and coming out of these types of premises prior to and at the conclusion of religious services. Greater flexibility, as I have previously said, is absolutely required when evaluating these applications. You should also be aware of the 2000 federal legislation, Religious Land Use and Institutionalized Persons Act, which is more commonly known as our LUPA. Pursuant to this legislation, a municipality cannot place a substantial burden on religious activity. In order to make a claim under our LUPA, the petitioner must show that the municipal board's denial imposes a substantial burden on them, and if they are able to show that, then the government must then show that their actions are in furtherance of a compelling governmental interest and that they are using the least restrictive means available to achieve this end. This legislation was recently upheld as constitutional as part of the Westchester Day School versus the Village of Marinette case in 2008. Our next LULU that we're going to dig into, if you will, is mining. The Mining Land Reclamation law, or MLRL, governs the regulation of certain mines, and it is found in the Environmental Conservation Law, Article 23, Title 27. For more in-depth information on the DEC mining permit process, please visit the Department of Environmental Conservation's website. Under the Mines Land Reclamation Law, the DEC regulates those mines extracting over 1,000 tons or 750 cubic yards in a 12-month period. Anything under this amount, the municipality can choose to regulate itself. Municipalities do have some options and freeways when dealing with land that is covered under this law. That is through their traditional zoning powers. For example, a municipality may choose to prohibit mining in all of the districts, as seen in the Granite Asphalt Products, Inc. versus the Town of Sardinia. Municipalities can also zone to allow in certain districts or areas if they so choose. The second thing is that municipalities can enforce generally applicable local laws that only have an incidental effect on mining. For instance, the construction on steep slopes, building permits, or wetland issues. And finally, municipalities should participate in the DEC permitting process, though this will be limited by the Mine Land Reclamation Act. As I previously mentioned, municipalities can also zone to allow in certain districts or areas, and this is often done as part of a special use permit. Often there are conditions attached to the special permit, and these are some of the topics that you often see. Egress onto municipal roads, transport of materials that have been mined across municipal roads, and then the enforcement of reclamation requirements that are part of the DEC's mining permit. Our next slide deals with non-retail uses in retail districts. There's a great deal of concern in some communities that have attempted to revitalize their downtown or Main Street areas that allowing non-retail uses diminishes their ability to achieve the critical mass of retail and service businesses that draw people downtown and create vibrant urban environments. Non-retail uses can impact many different things, including the amount of sales tax, pedestrian traffic that's created, and the retail core of the community by decreasing the amount of space available for those retail users. Some zoning tools that can be used to deal with this issue are requiring a minimum percentage street level retail in new development. For example, a retail space having on its ground floor of either a parking complex or a new hotel retail space, instead of having it just be part of the hotel or part of the parking complex. Another tool would be special use permits for non-retail uses on first floors. The Department of State offers several training modules that have more information on the revitalization of downtown and Main Street areas, and I would encourage you to take a look at those descriptions, also available on our website. Our next topic will be billboards. Since billboards are large freestanding structures, they create unique problems for land use planning and development, precisely because they are designed to stand out and apart from their surroundings. The courts have found a legitimate local interest in controlling the size and location of billboards, but not in controlling their communicative aspect. This means a municipality can regulate the time, place, and manner of billboards, but not the content of those billboards. The issue of sign content will also be touched on one of our later LULUS, the topic of political signs. The Federal Highway Beautification Act of 1965 requires that the state control off-premises signs visible from areas adjacent to primary highways, highways on the National Highway System, and interstate highways. The New York State Department of Transportation, or DOT, may be consulted for more information on sign regulation that applies to sites adjacent to state and local routes covered under the state's program for control of outdoor advertising. The New York State Sign Program, which implements the Federal Highway Beautification Act, is designed to control the erection and maintenance of signs along primary highways, federal aid highways, and the National Highway System along interstate highways. Elements of the state sign regulations include sign type, location, which includes zoning, size, spacing, lighting, and registration requirements. The New York State DOT and the New York State Thruway Authority administer the program and regulate signs within their respective jurisdictions. Section 361-a of the Public Authorities Law restricts advertising This is within 660 feet of the New York State Thruway right-of-way. Beyond 660 feet, off-premises signs is prohibited by the Department of Transportation in all but urban areas. Within the Catskill and Adirondack Parks, the Department of Environmental Conservation, or DEC, administers additional state requirements which limit the signs authorized in these parks. For more information on the state's regulation of billboards, please see the Department of State's publication available on our website and entitled Municipal Control of Signs. Now, what's left for local governments? Local governments may still prohibit signs where DOT would allow them if their regulations are equal to or stricter than the state's regulation. In New York State, the Court of Appeals has upheld local laws that prohibit all off-premises commercial billboards. So what are some of the methods that municipalities could use in terms of regulating billboards? They can look to the State Uniform Building and Fire Protection Code. They can look to their local zoning to use that. As part of that, they can develop site plan review for the placement of billboards, or they could just have a local permitting process for the placement of billboards. It's important to remember that any of these municipal regulations must only deal with time, place, and manner restrictions and not the content of the billboard. Our next topic is the topic of mobile homes. Mobile homes have been a housing option in the state of New York for more than 60 years. Mobile homes first appeared in New York State case law in 1939, when the courts held that a regulation requiring a permit for an occupied trailer on a private lot for more than 48 hours was invalid because it was an overextension of the municipality's police power. Mobile homes continue to be an affordable housing option throughout the state and the country. At this time, I'd like to draw your attention to a publication also available on the Department of State's website entitled Municipal Regulation of Mobile Homes that can provide more in-depth information on the regulation of mobile homes. It's important to remember that you can't exclude all mobile homes from a municipality, and there are 3 levels of regulation that apply to mobile homes. The first level of regulation is federal and comes from the Federal Manufactured Housing Act of 1974. This act was adopted to deal with construction and safety issues and was in response to a high number of injuries and deaths resulting from construction defects in mobile homes. Mobile homes manufactured after 1976 must display a HUD seal or data plate to verify their proper construction pursuant to this act. Municipalities may regulate mobile homes without a data plate differently than those with the plate. However, if the pre-1976 home can pass the structural, electrical, and other required inspections, it must be allowed wherever similarly sized HUD-certified mobile homes are allowed. Municipalities may not make a distinction based on the age of any homes which do have a HUD seal, such as only allowing mobile homes less than 5 years old to be placed on individual lots. Our second level of review comes from the state and deals with installation standards. The New York State Uniform Fire Prevention and Building Code, which is found at 9 NYCRR Part 1220, provides that manufactured homes and mobile homes are to be constructed and installed in accordance with the regulations adopted by the federal government. Also pursuant to the Manufacturer's Manual, the Sanitary Code, Part 17. Municipal regulations of mobile homes have been justified by a municipality's response to the assurance of adequate municipalities find their justification for the regulation of mobile homes in their responsibilities to assure adequacy of water and waste disposal, environmental protection, and adequacy of police and fire protection, and other municipal functions which further the health, safety, and general welfare of the community. This requires a balancing of an individual's interest in using their property, the public's interest in affordable housing, and the municipality's interest in conserving resources and planning for the future community development. Mobile home regulation can provide a viable way to achieve this balance. Many local regulations address such issues as the location of mobile homes, the lot size, the setback requirements that are applicable to these homes. Also, home site development for mobile homes in an effort to address the local health, safety, and welfare issues have been employed. It is important to remember that if you're dealing with an agricultural district, that a farmer may, within a state agricultural district, be allowed to house farm workers in manufactured homes on the farm lot. This cannot be prohibited. Our next slide deals with group homes for the disabled, or site selection of community residential facilities. This will be governed by the Mental Hygiene Law, Section 41.34, which is sometimes referred to as the Padovan Law. A community residence established pursuant to this section and family care home shall be deemed a family unit for the purposes of local laws and ordinances. This was placed into the Mental Hygiene Law to end disruptive litigation over community residences being located in residential zones. When a group home is to be sited in a municipality, the chief executive officer of that municipality will be notified by the home sponsoring agency. The municipality may then either accept the site proposed, try and offer other suitable locations, or object to the location due to an overconcentration of community facilities in the municipality. Municipalities that choose to challenge the siting of one of these homes must address whether the new facility results in such a concentration of community residential facilities for the disabled, or a combination of such facilities and other facilities licensed by other state agencies, that the nature and character of the areas within the municipality would substantially be altered by the siting of that home. This is a very difficult burden to prove, and it lies completely with the potentially hosting municipality. Our next slide deals with large-scale retail uses. Many municipalities are facing the proliferation and/or initial establishment of large-scale retail uses or big box stores. These stores often do not fit in with either the scale or the look of the community. Municipalities have employed several different options in trying to address this issue, such as establishing a maximum size for retail space, such as 10,000 feet or less. This should be done ahead of time before one of these large-scale retail uses attempts to locate in your municipality. You can also set thresholds or special use permits for retail uses over a certain size. Another issue that's often looked into is architectural and design elements. Basically, this helps to make the large box retail user look more like the rest of the community, just on a larger scale. Parking spaces is often an issue, including the appropriate number, the location. A lot of places are now looking at placing parking behind a store and having more trees involved. Landscaping, also a large issue these days, has become permeable surfaces. Sign standards, whether or not their sign standards conform with the rest of your community, and then of course what their outdoor storage is going to be, the amount, the location, and the design, whether or not things that maybe need to be screened will be properly screened. As previously mentioned as part of the billboards, I said that we would get back to political signs. Some local governments have attempted to deal with the clutter of election campaign signs by limiting the period in which they may be posted. Typical local regulations specify a period after an election by which such signs must be removed. Some local regulations also limit the posting of such signs to a specified period before a primary or election, or the number of signs that may be posted. If challenged, such local regulations are likely to be struck down by the courts as an unlawful interference with the right of free expression as guaranteed by the First Amendment to the United States Constitution. The main flaw in a local law ordinance that applies specifically to election signs is that it imposes restrictions based on the content or the message of the sign. Local legislation that regulates signs must be content neutral, meaning that it must apply equally to all signs regardless of the message. Restrictions on non-commercial signs, including those that support a candidate, must only be limited to time, place, and manner of posting, and must adhere to the following criteria. They must be content neutral, i.e., they affect all temporary signs in the same manner. 2, they must be narrowly tailored to serve a significant governmental interest. And 3, they must leave open ample alternative channels for speech. Regulations regarding the placement of signs can be based on traffic safety, aesthetics. Does that sound right when it's coming out of my mouth? Aesthetics?
That's right.
Okay. Regulations regarding the placement of signs can be based on traffic safety, aesthetics, economic development and property values, but again, it is important to reiterate, it cannot single out a political sign for this type of regulation when other non-political signs are not covered by the same regulations. Municipalities can regulate physical characteristics such as the material, size, and the like of the sign. Most municipalities, in fact, treat political signs as temporary signs, similar in nature to the real estate signs, garage sale signs, and other signs of a temporary nature. In the regulation of these signs, you can consider such issues, again, as size and height. Location, you can ban all signs from public property. That would mean things like the right-of-way, parks, town hall property. Whether or not there's going to be fees related to the administrative costs for processing an application to place a sign. A permitting process that would have anyone who wanted to put a temporary sign up apply to the municipality. You can also limit the time duration for which the sign will be up. It's imperative that this be applied evenly and linked to a generic event. For example, an example would be a temporary sign needs to be removed within 30 days of the completion of the event that it is referencing, as opposed to 30 days after the election. This would be, again, signaling out political signs specifically. There is a legal memo entitled Restrictions on Political Signs available on the Department of State website, and information on political signs is also included in the Department of State publication Municipal Regulation of Signs, which is available on the website as part of the James A. Kuhn Technical Series. Our final Lulu for this presentation is the topic of McMansions. This is a relatively recent development where we have seen an incredible increase in the number of larger homes or expansion of smaller homes. In 1950, the average size of a Levittown home was less than 800 square feet. Levittown, as many of you know, was one of the original cookie-cutter subdivisions located in the state. In 2002, the average size of a home in Levittown was 2,114 square feet, a substantial increase. This rapid increase in the square footage of homes is at least partially the result of the teardown phenomenon. The teardown phenomena is the purchase of land with an older house on it, the immediate tearing down of that house, and its replacement with a modern house which is out of scale with the character and the surrounding residences in the neighborhood. Monster houses or McMansions put surrounding houses out of scale. They can erode community character, and they often build right to setback lines. The teardown phenomenon is dominant in 1950s area neighborhoods, which are too new to be considered historic and therefore are not provided with the same teardown protections as historic homes. Some of the things that a municipality can do to deal with this issue include requiring demolition permits for older homes. You can also choose to limit the size of a residential structure and establish a floor area ratio, or a FAR. FARs limit building mass by restricting the maximum size of a building as it relates to the size of the lot upon which it sits. Another method can be to establish a way to measure height of the building. A third idea is to establish a way to measure the height of building and the numbers of stories. When doing this, be sure to specify the point of measurement. For example, carefully define that height is measured from the existing grade. Another method is to establish a gross floor area, the sum of the gross floor area of all floors, Another method is to establish a gross floor area. The definition of this is the sum of the gross floor area of all the floors, but excluding any space where the floor to ceiling height is less than 6 feet. The gross area is measured from the exterior faces of the exterior walls or from the center line of a party or common wall. All portions of the structure space with a height of 14 feet or greater from floor to ceiling shall be calculated as 2 floors, and each additional 7 feet as an additional floor. Included as a measurement of the floor area are all interior stairways, elevator shafts, utility rooms, roofed porches, roofed carports, attached garages, roofed decks, unenclosed breezeways, roof decks, and balconies. Excluded from this measurement would be a basement to the extent it is located 4 feet or more below the surface, and any portion of an interior space with structural headroom of less than 6 feet. You may want to limit the gross floor area to 2 times the footprint and define the gross floor area to include open ceiling areas, attached garages, interior stairways, as I previously mentioned. You may also look into limiting the squarification of homes by requiring upper floors to be set back and also control side yard setbacks. You may want to require site plan review for homes over a certain size and or the increasing or enlarging of an existing home by a certain percentage. You may also want to look into limiting accessory buildings to a certain percentage of the lot. As you can tell, there are a number of ways to look at this issue, and I highly recommend you explore your many options before making a choice. Now that we've discussed the LULUs that we've had laid out as part of this presentation, I'd like to talk a little bit about defending your decisions. Since the issues we've discussed as part of this class are often contentious, your municipality may find itself needing to defend its action. This does not mean that your municipality has done anything wrong, but you will still need to provide evidence that what you have done complies with the law. If you have to defend a local land use decision, the first place to go to find supporting information is the record, which is the assembled facts of the decision. The material in the record tells the story of the application, and it should illustrate common items that include newspaper notices. This will show that public hearings were held on proper notice. Also, you may want to show that all other appropriate legal notices were served on groups such as the county or other agencies that may be involved. Meetings of minutes should also provide a good deal of information. You should also have the application and supporting documentation. If everything was done properly, the decision should be reflective of what the application and supporting documentation show. You want to include your seeker materials, any testimony that was given at public hearings, and also anything that was written and submitted from the public. Expert opinion should also be something you look into here, and that could include information from engineers, attorneys, planners, or anyone else in a similar situation. And then, of course, the decision should be looked at, and the conditions that are attached to it and any findings thereof. Which brings us to drafting the findings. Drafting your findings is the local land use equivalent of showing your work in math. Your decision needs to be supported by findings. And being able to support your decision with good findings is what will protect you when you go to court. Which leads to the question, what are findings? Findings describe the reasons for the denial or the approval of an application and may also support why a condition was imposed on a particular application. Findings should mesh with existing law. If they do not, you could have a potential legal challenge. Findings should be able to support a decision if it should be challenged in court. Examples of not doing this would be finding a project in compliance with zoning that has no environmental impacts, but deciding against it anyway with no particular reason behind it. That's when a decision will be challenged and the findings will not back up your decision. Conclusory statements are not findings. A decision based on conclusory statements, which is not supported by factual information contained in the record, will likely be struck down. An example would be, a conclusory statement would be, this project will create more traffic, but having nothing to base that actual statement on, other than you just think it will create more traffic. If you had a traffic study or more information perhaps from the Department of Transportation that supported that, it would no longer be conclusory. What could be the possible content of findings? All sorts of things could be included. The comments and information offered by the applicant and any interested groups. This could include local civic organizations and neighbors. Another thing would be the action requested by the applicant. What exactly were they looking for? That's important. Property information, the ownership status, the use of the property. Is it a prior non-conforming use? Also want to look at what the zoning is of the area and the surrounding area. What does the surrounding neighborhood look like? Do things all follow along the same type of flow? Are they all the same type of houses? Is this a historic district? The analysis of the board should also be looked at. How they went about making their decision and what the decision was actually based on. Legal standards. Does the application need to be treated differently for one reason or another according to the law? Make sure that your findings support the legal standards that are applicable. And then, of course, finally, the facts as they relate to legal standards. This is by no means a complete list. Hello again, and thank you for watching the entire presentation of locally unwanted land uses, or LULUs. I hope that you have enjoyed the presentation and gained a lot of valuable information. I highly recommend that you take a look at some of the presentations I mentioned during the slideshow, including a number of publications that are available on the Department of State's website. They will afford you an ample opportunity to look into many of these issues in greater depth. If you have any follow-up questions, please contact either the Department of State Counsel's Office or the Department of State Division of Local Government. Either one of these groups would be happy to help you with any questions you have. Thank you so much for, again, participating in this program. I hope you continue to enjoy your training as a member of a municipal board. And until we meet again, have a good day.